one of the things that I think people should be mindful of is it's about control. So in mediation, there's going to be a lot of control dynamics, right, that are at play, but also you don't have as much control in the system as you maybe do in mediation, right?
Exactly.
And you have control over presenting your situation in a certain way and preparing for the mediation. And maybe we could start there, because we encourage people to prep for mediation, and not like an hour beforehand, like a couple weeks. Get your financial picture, get your evidence, like almost go to mediation like you were prepping for trial. So where are you on the spectrum of like encouraging business owners to be prepared, or even, prepping them in some capacity if somebody comes to you and's like, hey, how do I get ready for mediation? Like, what would you talk to a business owner about in that respect?
They're all great questions. You use the term control. I use the term self-determination in mediation. It's the only opportunity for parties in a dispute to control or resolve it based upon their own decision making. If they go to court, it's going to be left to a judge or jury, and they are completely out of control. There's no self once the matter is turned over to a judge or a jury to make a decision. And it can be very frustrating if you've lived with a problem to leave it to someone else's hands who may not ultimately understand it to then make a ruling about. The best person to reach a resolution of a dispute in a commercial context, or even certainly domestic, are the people that are involved themselves, the people that are suffering through it. So self-determination. To your question about preparation, it is essential. If you go into a mediation without knowing your numbers, your damages, a calculation of your goals with respect to the dispute, you're going to be wasting your time. And I have to admit, I've been in those situations where I've tried to warn the parties and their counsel to come to the mediation prepared, ask for mediation statements to help them get prepared. And they've taken certain steps, but missed many others. And if I could point out probably the biggest mistake in terms of not preparing for a mediation is for counsel not to prepare its client for what a mediation is and what is intended to happen in a mediation. I can't tell you how many times people have come in and thought I was the judge and tell me the story as if I am deciding their fate, as if I'm making the ruling. I'm a neutral. I've got no decision making in a mediation. And if they come in thinking I do and I don't, there's a lot of anxiety and sometimes anger about the process that they were never prepared for. And again, things can go off rail pretty quick.
Mm-hmm. Right. And commercial mediation is different, a lot of times. And if we just set the stage for like what to expect in that, typically we're having the clients or the business owner and their lawyer come in for both sides, right? So the mediator is typically doing like a caucus style. So going back and forth, we facilitate it on Zoom in rooms, or you do it in person in rooms, right? Now, what I have counseled, because of course I'm on the business valuation side, and a lot of times a commercial litigation or a commercial mediation is going to govern, like a contract issue, a dispute about payment, some sort of, you're buying out a partner and what is the value that you're buying them out. A lot of times what I'm saying to them is, instead of making this so robust and creating like a position statement or a mediator position that's like 10 pages long, right? I'm encouraging them to come up with a 1 or 2 page. And they're like, I can't put this in 1 or 2 pages. I was like, yes, but if you try, you're going to get very, very clear on what you want. And what, if I say you only get 3 issues and you have 10 issues, I want you to start to identify the really big issues.